First and foremost, thank you everyone for tuning in to today's session. I have the pleasure of introducing Prashanthi. Prashanthi is has vast experience in the field of immigration since 1997. She has been admitted to the bar in New York. She is currently a member of the American Immigration Lawyer Association and the New York Bar Association. Prashanthi holds various positions in different associations, including immigration chair for the National South Asian Bar Association, immigration co-chair of the Federation of Indian Associations, and she's currently actively involved in pro bono legal work. So once again, invite Prashanthi, and Prashanthi, the floor is yours.
Thank you. Let me just maximize my screen. So I thought we would start today's H-1B webinar with the hot topic of the hour, which is basically what is collusion and what is not collusion. Everyone really has been talking about, has been thinking about or calling me about whether they should file their H-1B this cap season or not, and their concerns are basically that, twofold. One is that in some instances the employer may have colluded. In some instances there's no collusion, but they think there's collusion. So I think we should start off with, even before we start getting into how to file a successful H1, how to tackle an RFE or avoid an RFE if we can, as to whether the H1 should be filed or not in the first place, and in which instances a H1 should be filed, and in which instance we should avoid filing simply because of the new H1B registration issues that we've had this year. So just to take a step back, USCIS received many registrations this year. When compared to last year, it's almost double, 780,000, I believe. And out of that 780,000 registrations, there was about 400 plus duplicate registrations. So when I say duplicate registrations, we're really talking about the same beneficiary filing registrations through several companies. And USCIS is aware of that. They sent out a report informing us how many registrations were duplicate, and et cetera, et cetera. As a result of which, because they've realized there's so many duplicate registrations, they've also sent out a press report with reference to the fact that they think that a lot of companies colluded to file registrations, and that is not allowed. So I think and so they plan to enforce that law with reference to collusion and go after some of the companies that have colluded. So let's talk about, because of this unique scenario, I think the number of duplicate registrations this year, the percentage of PICs has been very low. Usually it's about 20-30%. This year, the percentage of PICs has only been 7% because of all the duplicate filings. And as a result of which, USCIS is worried that their whole H-1B registration process may not be working. So they want to make sure that the process works. And so they're trying to enforce more, and so that there's not that many duplicate registrations next year. So they're trying to seriously go after those employers who have done collusion. So what is collusion? I think we should start off with what is collusion, so we know, what is allowed within a duplicate registration scenario and what is not allowed. So when a group of companies say, and this diagram will help, the group of companies say employer 1, employer 2, employer 3, all of them together, they decide to file registrations for beneficiary 1, 2, and 3. So employer 1 has filed for the 3 beneficiaries, employer 2 has filed for the 3 beneficiaries, and employer 3 has also filed for the same 3 beneficiaries. I'm just giving an example. It could be 20 beneficiaries, it could be 30, it could be 3. In this case, USCIS calls this collusion because as per USCIS, if companies collude together to file registrations for the same beneficiary or set of beneficiaries with the sole purpose of increasing the chances of those beneficiaries getting picked in the lottery, then that is collusion. And USCIS announced in the beginning of the registration season that they are also going to put in an attestation, in which they did. So when you file the registration, you are signing off under the penalty of perjury that you're signing off on an attestation that you did not collude with any other employer to file multiple registrations for the same beneficiary through these different employers. So this is something that is not allowed. So any of you companies, if any of your, whether it be the employers or the employees, if this situation has occurred, then it is collusion, and I suggest that those employers don't file their H1, and I suggest that those employees don't allow the employers to file those H1s. So that's what collusion is, and that's not allowed. So let's go and see now what is not collusion, because of this whole thing. Let's go to the next screen, Michelle. Because of all this, there's been a lot of rumor and a lot of information that is being passed on as to what is collusion and what is not. So this is basically the language of what is the attestation language, is basically that I further certify that this registration or these registrations reflect a legitimate job offer. So that's the first attestation that you're making. And that I, or the organization on whose behalf this registration is being submitted, have not worked with or agreed to work with another registrant, petitioner, agent, or other individual or entity to submit a registration to unfairly increase chances of selection for the beneficiary or beneficiaries in the submission. So this is exactly what I explained. This is the attestation that you signed off on, but people didn't take it seriously, and they actually did commit collusion because they thought that it would not be possible for USCIS to actually find out that the companies were related. But what's happening is USCIS is not even bothering to look into whether companies are related or not. They're just, if they see a group of companies and they see there are several duplicate registrations within those group of companies, say company A, B, and C all have filed 30 registrations and the 30 registrations all have the same list of beneficiaries, then they're presuming that it's collusions, and they send out an RFE or a notice of intent to revoke or deny, depending on in what instance they send it out. And they're saying that, look, all these are common beneficiaries. It can't just be coincident. It can't be an instance of coincidence. You guys must have colluded together. And then you have to show to the USCIS that there's been no collusion. So really, even if the companies are not related in any way or they can't find a relationship, they're alleging collusion. In some instances, they're able to find a relationship in the companies. They're able to find bank information that's common. Maybe they're able to find office space that is being shared, or perhaps they're able to find a business relation, such as a petitioner, vendor, and a sub-vendor, a client kind of relationship. So as I said, even in the instances that they don't find a relationship or they can't find one with the available public information, they're still alleging collusion, and then you have to show that it isn't. Next slide. So what is not collusion? So in not every instance, simply because there's a duplicate petition, it is collusion. So in this diagram that you see that the beneficiary individually filed a H1 with employer 1, 2, and 3. And employer 1, 2, or 3 did not come together and decide to file a registration for the beneficiary. The beneficiary independently sought out employer 1, 2, and 3 and filed through those three companies. So if the beneficiary seeks out 3 different employers and files independently through 3 of them, then that's not collusion. It is not. So this is the most common misconception. A lot of beneficiaries don't want to file because most of them have filed through several companies, but this is allowed. That's why they did that. USCIS cannot prevent beneficiaries or did not prevent beneficiaries from filing duplicate registrations. They only prevented employers from filing the same duplicate registrations for the same beneficiary and also colluding with other companies to file duplicate registrations through a group of companies. Okay, so independently beneficiaries finding employers and filing duplicates is allowed, no matter what you're hearing. Maybe there are some cases where USCIS has sent an RFE, but that is not against the law as per USCIS regulation. So even if they send an RFE, we can respond to it because they can't. They have to follow the law as well. Okay, so that's completely allowed. The other instance where duplicate filings are allowed is, say you have 3 companies. You own 3 companies. Joseph owns 3 companies, company A, company B, company C. And Joseph files a registration for John in all 3 companies. It is not collusion. It is not duplicate filings. If the job is different, meaning for company A, you have a job lined up for the beneficiary with AT&T. With company B, you have a job lined up with Citibank. With company C, you have a job lined up with Chase. So it's 3 different job offers. So that is not collusion and it is not duplicate filing. So that is allowed, and it has always been allowed by USCIS, as long as the job offer is different. So I hope that's clear as to what is collusion and what is not, and who can file a H1 and who cannot file a H1. I hope it's very clear to all of you, as to who can file and who can't file. I can't stress this enough because I get so many calls every day from the employers saying that, oh, the beneficiary doesn't want to file because what? He says he did 5 registrations through different companies. That is allowed. Or, sometimes I get companies saying, oh, we colluded. Should we file? And I tell them, no, you shouldn't. Because USCIS will come after you, most probably. They might still come after you even if you don't file, but the chances of them coming after you for collusion if you don't file is less when compared to if you do. So also with reference to the bona fide job offer with for the attestation, that's another issue that some people have been worried about. They haven't really been enforcing that, and it's hard to prove with reference to bona fide job offer whether you have it or not. Usually you have to prove that at the instance of the filing of the H-1B petition, not at the time of filing the registration, because everything with reference to eligibility has to be shown at the time of filing the H-1B petition, not really at the time of the registration. Even, for example, if you're filing a master's cap registration, you don't even have to show that you have a master's degree as of the date of registration, but you have to show that you have one at the date, as of the date of filing the H1. So just remember that all such requirements have to be met at the time of filing the H1, not at the time of the registration. So even if you didn't have a bona fide job offer at the time of registration, you can always show that at the time of filing the H1. So you're not really attesting to something wrongfully under the penalty of perjury. Also, availability of job offer is something that is difficult for USCIS to deny based on, because especially with some of the cases that have come out recently with USCIS IT Serve versus Cessna, where they have said that in that particular lawsuit that employers, USCIS cannot ask for detailed itineraries and contracts to show that a person has that the employer has a job at hand for the employee. In that instance, then them asking for a valid job offer can only be limited. So as long as you show that you have something, some PO, some contract, or if they're working in-house, some kind of documentation, I think that should be sufficient. I think the next leading question would be then, since a lot of people are not filing, so a lot of companies who have actually practiced collusion will not file. So then will that lead to a second lottery? Because a lot of the numbers then will not be used. Typically, when USCIS picks a lottery, they take into account that some cases will not be filed. But since this year it's been an unprecedented amount of duplicates, and we can presume that a lot of those were cases of collusion, we can presume that a lot of cases will not be filed by the employers. Beneficiary should still file, as I said, if it's not collusion. So since a lot of filings will not be done, a lot of the the registration numbers will not be used towards a H1. Therefore, USCIS, I think, most probably will have a second lottery. We have to wait and see, but I'm thinking that my prediction is and USCIS does not want, hopefully does not want the numbers to go waste. They will have a second lottery. Of course, there is not much, unfortunately, there's not a lot of clarity on this. And USCIS doesn't really share all the information with us. So we have to wait and see. We don't really know how many cases are wasted, how many, so we just have to wait and see because they're not very honest with us with reference to whether they're using all the cases or not. They're not transparent, so we have to wait and see. But I think there will be a second lottery. We can go to the next slide.
Sure. Before going to the next slide, Prashanthi, I just want to remind everybody, we're already seeing a few questions coming. We do have a Q&A session by the end of the presentation. So if you have your questions, you can either put it in chat now or wait till the end so that we can pick up your questions. Thank you.
I see a lot of questions are with reference to what I already said. So people just want reinforcement. Because I have been seeing the questions, they're just asking the same thing that I've just said. So people just want reinforcement because yes, there's so much rumor going on there. There's one thing is, and it could not be rumor. Maybe there is an instance where USCIS has, in an instance where the beneficiary, for example, has filed their H1 last year. We're talking about last year, and they filed duplicate H1s, which is allowed. I'm talking about the allowed scenario. They still got an RFE saying that, you filed several H1s, blah, blah, blah. But that doesn't mean that they can deny it. And if they do deny it, then you have to appeal it because they're unlawfully denying it. You have to remember that. Never be afraid of doing what is allowed by USCIS itself. Sometimes consulates are asking those questions as well, and I've heard that. But that doesn't mean that they're allowed to ask those questions. Again, you have to litigate. So, of course, the good thing is that I'm sure USCIS will come up with with the resolution to all this. So right now, I think they're just keeping mum because they want to, because they don't want too many people to file. But there are lawsuits being filed, and this will be very clear as to what is allowed and what is not. And USCIS can't do anything about it. Beneficiaries are allowed to file multiple registrations. And there's not much, if the lawsuit is filed, USCIS can do about it. And there are lawsuits being filed. Even if they don't agree to what they themselves have written, because it's not convenient for them to agree at this point because of the number of registrations, and they're worried that the whole registration process is falling apart, which is true. They should have thought about this before they thought about such a system, or they allowed duplicate registrations to be filed, but they didn't. That's typical USCIS for you. And now they don't know what to do. So they're trying everything possible, but they have to remain within the scope of the law. They can't deny cases outside the scope of the law. So I think with that, let's get through, and we'll answer all those questions that are coming up as well. Let's quickly get through tools to avoid H-1B RFEs, what to do, what to expect this season with reference to RFEs. You guys are all filing your H-1B petitions. You have to know how to file a perfect petition or near perfect petition so you don't get a H-1 RFE, because if you do get an RFE, your chances of approval become lower. Your time taken for the H-1 to get approved increases. So you want to avoid an RFE, especially if you can. So the most important reason why you would get an RFE is the very basis for the H-1B, which is the specialty occupation. So if you fail to establish that your H-1B petition qualifies as a specialty occupation, you will get an RFE. And in recent times, USCIS has narrowed its interpretation of who qualifies and who doesn't qualify. And they also look at the job duties to see what job duties appear to be complex enough to require a bachelor's degree. They also look at various sources. They look at industry standards. They look at a website called the Occupational Outlook Handbook to see whether a bachelor's degree in a specific field is commonly required in that job or not. They also look at the job description to see if the beneficiary's education is closely related to the job. So, for example, if you're filing for a software engineer and say you have an engineering degree in chemical engineering, then you may not qualify because chemical engineering is not related to computer science. Though there are some courses that are common. They think that USCIS will definitely RFE that and say that it's not related. So before you can get an RFE while you're submitting the petition, you should get an experience evaluation done. If you have 3 years of experience in the IT field, if you get an experience education evaluation done to show that a combination of experience and education gives you the equivalent of a bachelor's degree in computer science or information systems or something related, you should definitely get that done. That would require you to submit experience letters to the evaluator, but I think that's something that you should get done before filing your H-1B petition, so you can avoid those kind of RFEs. So specialty occupation is definitely one of the most important reasons they send an RFE. So when you are putting down your job description, when you give it to your attorney or your employer, and you put it down, the employer puts it down in the petitioner letter, you have to make sure that the job description is sufficiently detailed, and you have to make sure so that USCIS can see whether it requires a bachelor's degree or not. You have to make sure it's sufficiently complex. And also, as I said, you have to make sure that the job description fits in with your educational qualifications. Next slide. So the second most important reason they send an RFE, and it's becoming less and less common now because what I mentioned with reference to ITServe versus Cessna, before they used to ask for an itinerary for the entire 3 years of duration of the H-1. They used to ask for contracts, purchase orders, especially if you're a consulting company. more often than not, they would ask for all that information. So though it's not to that extent, it hasn't gone away completely. The availability of work is still a reason why they could send you an RFE. So if they think that if you are a consulting company and you send out a petition without showing where the beneficiary will actually work, without saying anything about that, because consulting companies usually place their employees at different work sites or with different clients. If you don't say which client, you don't mention the project, you don't mention anything, then they'll most probably send you an RFE saying that, okay, we have to show that this is a specialty occupation, and we don't see what the specialty occupation work is. You've sent us a job description, but where is he actually going to be performing that specialty occupation work? How do we know that he'll be performing that specialty occupation work? So usually we ask the client in the consulting scenario to send out, POs or something, a vendor letter, a PO, an MSA, some minimum documentation to show that you actually have work. If the person is working in-house, then you can maybe send out some contracts to show that you have business, just to show the scope of business of the company. But it really depends on the type of business. If you're, for example, a law firm, you don't really have to show scope of work. If you have, sufficient revenues to be able to hire an additional person, and even that is a chicken and egg situation, because you can argue that you will get revenue after hiring because you're expecting to expand your business. So in that kind of scenario, really the scope of work is not, or availability of work is not looked into as much. But in some other situations where it's a consulting situation, they may send you an RFE on that particular subject. So it's good not to send out skeleton petitions. Next slide. So we were discussing this, right? The beneficiaries qualification. We discussed this a little bit with reference to specialty occupation. So USCIS can send out RFEs to establish that the beneficiary was qualified to perform services in a specialty occupation. So the employee should give their degree copies, their mark sheets or transcripts, so that USCIS can look into the subjects that they study. Sometimes you could have majored in something like engineering, but it's not clear as to what subjects you actually took. That's why transcript is really important, so that USCIS can see how many subjects you took that are related to the job at hand. And sometimes it helps to actually put that in a letter and preempt an RFE by just listing out the subjects that are related to the job at hand. And of course, an evaluation helped. And as I said, a work experience evaluation definitely helps. And sometimes if the degree is related without work experience, but it's not clear that it's related, as I said, educational evaluation could help. Also, sometimes USCIS routinely asks for, even if you have a bachelor's in computer science and you're working as a software engineer, USCIS routinely asks for educational evaluations if the degree is from a foreign country. So sometimes, an evaluation might be required anyway. Next slide. So how to avoid, so another way to avoiding H-1B RFEs is maintenance of status. USCIS requires RFEs, sends out RFEs to beneficiaries who don't properly maintain their status. Maintaining status means, if you're filing for a change of status from some status to a H1, or even if you're in a cap situation, say you're filing from an F1 to a H1, you have to submit documents showing maintenance of status. So you have to submit I-20s, you have to submit like EAD cards, if that's your status. You have to submit an I-94, say if you're On a H4, you have to submit an I-94 to show that your status hasn't expired. You have to submit I-797 approvals to show that your status hasn't expired. If you're already in a H1 and you're filing a transfer or an extension, you also have to submit pay stubs, because that's the only way to show that you're in status, if you're actually working for the employer, not just the fact that your I-94 is current. Okay, so the other reason for denial of a H1 or RFE, which we can preempt, is again availability of work. I think we've covered this. This is more with reference to in-house work. So if you have a consulting company and you're saying that your job is, you have to prove that your job is non-speculative, which means that you can't say that you're filing the H1 now and then you'll decide later where to place the your employee, or maybe you'll look for a job later for the employee once they get the H1. That's called speculative employment. That's not allowed. So if you're placing them in-house, then you have to submit, first of all, documentation to show that you have enough space in-house. So you'll have to submit a lease, maybe photographs of your premises to show where they'll be working. And if they're working on a project, then you have to submit project documentation and maybe client letters or contracts to show that, you know, if you have a software, that someone is using that software. If the software is still in the development stage, then you might have to submit screenshots. If you have a patent, then, you know, that information, just to show that it's a genuine project and it's not something that is being created for the sake of getting the H1. Next slide. Yes, so the LCA is the labor condition application, and if that's not filed properly, previous to the H-1B petition being filed, then if you get an RFE on it, not much that can be done. The H1 will get denied, because you cannot go and then submit a new LCA, because the LCA has to be certified before the H-1B is actually filed. So LCA must be properly filed, signed, the position offered, the salary offered should all be correct and correspond with your H-1B petition. The work site has to correspond with the actual work site. So all this has to be looked into. So please examine your LCA carefully, file it carefully before you actually go ahead and file the H1, because this cannot be corrected later. Next slide. Now we all know that a H-1B has a 6-year limit. Please make sure when you're filing for your employee that, or if you're filing yourself as, you know, as a beneficiary, you're filing the petition, whoever you are, that you have not reached the 6-year limit. And if you have reached the 6-year limit, you have a way of filing. You have an exception. You're an exception to the 6-year limit. What are the exceptions to the 6-year limit? So if you are a beneficiary who has a pending labor certification and it's been pending for more than a year, or a pending I-140 that's been pending for more than a year, then you are allowed to file beyond your 6 years. You get an extension of 1 year. Or if you have an approved I-140, then you get an extension of 3 years on your H1. So these are the exceptions. Also, you're allowed to use the time spent outside the country. So in the last 6 years, so you say you spent 1 month outside the country every year. So you then get 6 years. You get 6 months more. You can apply for recapturing those 6 months for filing a H-1B extension just for those 6 months. So based on all these factors, you might qualify. If you don't qualify, please don't file your H-1B because it will get denied. And if you're filing one, make sure you show all this information up front. Don't just file it and expect USCIS to figure it out. They will send an RFE. Next slide. Fees, of course, that's most important. You have to make sure you submit the correct amount of fees. The fees is not as simple as you think it is. There are different fees for depending on the size of your company, etc. So please make sure you know what your fees are. Go through the USCIS website to look into that. Also, make sure once you know what your fees are that you write the correct amount on the check. You write the correct date, you write the correct amount in words as well as in numbers, you sign. The other day, we got a case come back, and this is the first time this has happened to us, because 100 was spelled wrong. So 750, they spelled 100 wrong, and they sent back the check. So just make sure that you also spell everything correctly. Next slide. Best practices. I think we're coming to the end of the presentation, then we have plenty of time for Q&As. Read the RFEs completely. Sometimes, there'll be 10 lines of nothing and 1 line that is important. So you might miss that 1 line which is important, or 1 word that is important. So please read your RFE carefully from top to bottom. Because it will be hidden somewhere. The most important part of what they're asking will be hidden somewhere in that RFE. So make sure you read it. Don't make any rash decisions. If you've received an RFE, don't withdraw it because you're scared. There's no reason to be scared. It's just an RFE is a tool by which the USCIS is trying to find out more information about your case because they have incomplete information. So nothing to be worried about if you get an RFE. Please just treat that as an inquiry from USCIS and respond to it completely. Don't answer your RFE in parts. Don't answer some and ignore others. It's not optional. You have to respond to the entire RFE. So please make sure you do that. Double check where you're mailing the RFE. That has to be, usually it's mailed to the address that it comes from, or where you send out the USCIS, where you send out the H1, but also double check where your RFE came from and send it to that address. There is a deadline to respond to every RFE. They usually give 84 days, but sometimes they might give less. So if it's a motion to reopen, it's only 30 days. If it's a notice of intent to revoke or deny, it's only 30 days, so don't presume. And with COVID, they had a 60 days grace period where they were giving 60 extra days after the completion of the RFE date. They don't have that anymore, so don't presume you have that extra 60 days. Respond before time or within the time, because you cannot ask for an extension if you do get an RFE. Next page. An RFE versus an NOID, a lot of people have a question as to what is a request for further evidence and what is a notice of intent to deny. Request for further evidence, as I just told you, is when they need more information. But if you get a notice of intent to deny, it means that they have found enough information, they want to deny your case, they intend to, and you have to show them why your case should not be denied. So it's obviously a strongly worded document, more chances of denial when compared to an RFE. So you have to put in more effort to make sure that they don't deny it or to refute whatever they're saying. And you often get only 30 days to respond to an NOID. RFE, you get a longer time. So you have to pay more attention when you get an NOID because you know that your case is likely to be denied. That's the difference. So just pay attention to an NOID.
And on that note, I'll open the FAQ, the Q&A session in this case. I do see a few questions already. Now is the time. If you have questions, please ask us, drop in your question on chat and we'll pick it up should the time permit. First question is, I have filed H-1B with 5 to 8 different companies, but I got picked up with 4 of them, but I am going with only one of my primary company.
There's no question there.
There's no question, that's a
just
statement.
a statement, but yeah, maybe they want me to validate if that's fine or not, which is most probably the case, but it's fine. Yes, go ahead. You can file a H1 with all 4 companies also and decide which one you want to use. Or you can just file with one company. That's fine as well.
Okay. Next question is, what is the process of CAP H-1B?
It's the same as filing a regular H1. You have to file an I-129, LCA, all your supporting documents, like I mentioned, showing status, etc., and showing availability of work. The difference for a cap case is the start date has to be October 1st. So make sure it is not before that, otherwise the case will come back. You have to make sure you include your registration notice in there, and the registration number has to be included in the H-1B data collection form. So there are a few things that you do differently, but otherwise it's pretty much the same requirements.
Okay, I believe you already addressed the next one, but the question was, what if a candidate gets an NOID?
Yes, so you have 30 days to respond. And an NOID is usually USCIS telling you that they intend to deny your case. You have to show them why you shouldn't deny. With respect to collusion, if you get an NOID, then you have to show that your company has to show that you did not collude, and that if there are any duplicate registrations with different companies, it could be that the beneficiary approached those companies. So usually if it's a small number, like say USCIS alleges that, oh, there are 3 companies that are filed for the same beneficiary, then you can easily say that we did not collude. The beneficiary chose to go with those employers and we don't know who they are. USCIS will always send out RFEs fishing for information, but that doesn't necessarily mean that it's true, whatever they're alleging in the RFE. So you can very confidently point out to them that there was no collusion. There have been instances where multiple cases were filed by several groups of companies, and still there was apparently no collusion, because what had happened is, and this happened last year, is they all got their resumes from the same source, from a recruiting company. Or from recruiting companies, and they all have the same batch of resumes. And so it so happened that they all filed for the same candidates, but there was no intention of collusion. So that's possible also. Just because there's multiple filings and several filings with same companies, USCIS might send out an RFE or a NOID, but that doesn't necessarily mean that there is collusion. You have to show that there wasn't.
Okay. As you rightly mentioned, a lot of the questions are more of a comment asking for reassurance. The next one is, have filed H-1B with 3 different companies, but I got picked with one of them only. Hope there won't be an issue.
No issue. Again, you are allowed as a beneficiary to file duplicate registrations. There have been 400 and plus duplicate registrations out of the 700 plus. Which means pretty much registrations, or which means that pretty much most people have filed duplicate registrations. There are very few who have not. And this is because it is allowed by USCIS. So go ahead and file your H-1B petition.
Great. Next one is client letter required at the time of stamping? If I present MSA document, will it work?
You don't need a client at the time of stamping. So at the consulate, in some instances, we've seen that the consulate is asking for the end client letter, even though they should not. There has been pushback from AILA and ITServe and other organizations saying that they should not be asking for the client letter. I've heard that the consulate recently has stopped. In some instances they're asking, but in a lot of instances they're not asking for the client letter. So I think with reference to consulate, if you have a PO and a work order, that should be sufficient. They should not be asking for a client letter.
There you go. Next one is, what if I got an RFE saying to provide legitimate offer letter from the multiple companies which I have applied, and if companies do not provide it, what can I do in that situation?
So in this situation, since you are the beneficiary, it is not your problem. It is the company's problem, because one of the issues, or one of the things that the company has attested to, remember, you haven't attested to anything. The company has attested to is that they have a valid job offer for you. So USCIS has really not come after that particular point. They said they're coming after collusion, but they have not really come after whether it's a valid job offer or not. They have informed employers that they need to keep information ready if they're not filing for a certain person who was picked They're only talking about picked people. So if they're not filing for a certain person that was picked, they want information. They might ask for information related to why it was not filed. So it would be a good idea from you, from the employer's point of view or beneficiary's point of view, from your point of view, to simply send an email to the company that a job offer can be oral as well. It doesn't have to be written, or it could be via email. So just send them an email saying that you are rejecting their job offer and because you found another job, or you don't even have to give a reason. You can just say that you're not accepting their offer of employment at this time, and if anything changes, you will let them know. That should cover the employer, and it's good for you also.
Next one is my STEM OPT expires on June 14th. I may get a contract job through my employer this week. Will I still qualify for cap extension if my LC approval goes beyond June 14th?
So as of the date of filing the H1, you have to show that you are on STEM OPT. So if as of the date of filing your H1, you're not on STEM OPT, then you will be considered to be in the grace period. You will not be out of status, but you will not get an extension on your STEM OPT.
Okay. Next question is, how about having electrical and electronics engineering with 9 years of IT experience? Would this be fine?
Yes, absolutely fine. You just need 3 years of additional IT experience to get an evaluation, educational work experience evaluation, education experience, work experience evaluation. So you'll be fine because you'll most probably get a bachelor's in information systems, which is related to a computer science position.
This one is it possible to start a new business and self-employ with the H-1B?
No, self-employment never gets approved because they do want to see some kind of an employer-employee relationship, and it's hard to prove that when you're self-employed.
Okay. How can I make sure the application filed are not colluding? Is there some portal or website where we can validate that?
So I don't know if you're the beneficiary or you're the company that's asking this question, but either way, whoever you are, I mean, if you're the company, you know that you colluded with someone. So you don't need any portal to figure that out. But if you're a beneficiary, then of course, you wouldn't know. And unfortunately, there's no portal. It's not public information, unfortunately. So you wouldn't know. You'd have to ask the employer. But if you have the employer should only be filing a H1 if you have given them permission. I mean, filing the registration even only after they got permission from you. So if you didn't give them permission, and if you didn't give multiple companies permission to do the H1, and you're not aware of any collusion, then most likely there isn't, because they would have to do it only with your consent.
Okay. We have 10 more minutes, so we will continue to answer a few more questions. Excuse me. In the meantime, I also wanted to inform everybody that as a token of appreciation for attending today's session, we will be giving away 2 free or 2 complimentary consultation sessions. So stick to the end of the presentation. We'll be sharing a booking link. You can book directly your consultation session. Please keep in mind this is early bird, so we only have 2 complimentary consultation sessions available. The next question is, if I get an RFE to provide legitimate offer letters from the companies I applied from, and if my employer do not provide answers for it, would my application get denied? And does it affect my existing OPT visa?
So as I said, the offer of employment, a legitimate job offer, USCIS has not been coming after that particular point as of yet. It's hard to say whether they will or not, or in what form or how they'll do it. But basically, even if you have an email from your employers saying that they offered you employment, it doesn't have to be an offer letter. And number two, you should not be getting this RFE. It should be more the employer getting it. So if the employer files, say, H1 for XYZ, and they have done registrations and maybe 20 have been picked and they filed only one. So for the one that they filed, they'll get an RFE saying that, you filed 19 other registrations. Why are you not filing the H1? So they'll get an RFE on their cases. They will not go after you because you did not sign any attestation or did anything that under penalty of perjury that you are not supposed to do. So they should not come after you. They will come after the employer that didn't file the H1 if they have to.
Okay, great. Now this one is a twofold question, so I'll ask in part. So the first part is, if once the change of status is taking place from F1 to H-1B visa, if for some unforeseen reason the H-1B visa doesn't go through, then does my F1 status still remain?
Yes, so if your H1 doesn't get approved, then whatever is your current status, that does not get affected because the change of status was not approved.
Okay. And the second part is, now hypothetically, if I get a job offer by this month end, and again, there is a submission of change of status from F1 to H-1B visa, would it create any problem in that case that I just got approved for F1 and again, I am immediately switching back to H1? Should I wait it out for a few months, or can I start immediately actively looking for work immediately?
Well, you don't have the luxury of waiting for a few months. If you've been picked in this lottery, then you should be filing. If you're a F1 to H1, I'm presuming you're subject to the cap. If you're picked in the lottery, then you should be filing by the end of the month, right? So you don't have the liberty of waiting for 3 months. Of course, you can wait until the next lottery. So you're not going to be picked again, but you can wait until next year to file. That's always a possibility. But I don't see, even if you've moved recently to an F1, USCIS might ask so quickly, they might have a question as to whether you're really on an F1 or not. But I mean, I think if you're able to show that you attended classes, etc., and the reason for you to go on an F1 and then reason to change, if it all makes sense, I don't see an issue.
Okay. Next one is, I have filed 2 different companies and I got selected one company. Now I got H-1B also. Is there any issue at the time of port of entry?
So this is a classic example. People are worried that if they file duplicate petitions and they go to the consulate, they're asking at the consulate why you filed, duplicate or whatever. That's not the case. And see, this person has gone to the consulate, gotten a visa. There's no issue here. And at the port of entry, they'll only look to see whether you have a valid visa or not, whether you have a H-1B approval or not, whether you have a job waiting for you or not. That's the only thing that they ask for. They're not going to go into the H-1B registrations. And even if they do, it's not something that you haven't done anything that is against the law. So they can't, on that basis, stop you from entering into the country.
Mm-hmm. If my H-1B application is under process, will I be able to travel to US on visiting visa since I have valid visa?
Well, if you're filing for H-1 consular processing, you can travel on a visitor's visa. They might ask at the port of entry what the purpose of your travel is. You could say, even if you have a H-1, you could still say, I needed to come in earlier to visit, or whatever the reason is. It shouldn't stop you from entering on a visitor's visa. But in order to activate your H-1, you would have to go leave the country again and get a H-1 visa and then come back in on a H-1.
Okay. Next is what if companies file H1 without my notice, and if I get RFE from USCIS saying to provide job offer letter from those companies, what can I do in that situation?
Well, if they have done it without your consent, I mean, first of all, they need a copy of your passport, so you must have provided it to them. But if they got the copy of your passport from somebody else and filed it, then you can simply say that you're not aware that it was filed and you did not consent to the filing of that registration.
Okay. Okay, so the same person has who has asked a two-part question. There was a third part. I don't know if we have time to pick that up. But what does it mean on the approval notice, duration of status, and how long am I able to stay on the status?
A person on an F1 always gets a DS as duration of status. They don't get a particular date, unlike H1 or H4 or the other non-immigrant statuses. The reason they put DS there is because as long as you're in F1 status, you remain in status. That's what DS means. So as long as you're going to school or as long as you're working or whatever your status might be, you're in status.
Okay. I think you've already answered part of it, but I'll still ask, is there any issue for multiple filing? I heard there is an attestation from USCIS has added this year. Does this affect multiple file candidate? Can attorney fight this?
If the beneficiary has filed multiple, then the attestation is not for that. The attestation is only about collusion, which is completely different from a beneficiary filing duplicate petitions. They're saying that a company should not file the same for the beneficiary through different companies. That's completely different from the beneficiary filing independently. I hope I made that clear. The distinction clear. I had the diagrams and all that out there, and I spent a lot of time on what is collusion and what is not. I hope it's clear. So the answer is please go ahead and file your H1 petition. And yes, any attorney should be able to help you because you have not done anything against the law.
Yeah, multiple filing seems to be the keyword throughout this session. Next
Correct.
one is just on that. Do multiple filing affect at the time of stamping?
Again, if there's no collusion, if you as a beneficiary have filed multiple registrations, that's fine. Should not affect you at the time of stamping. I have heard some instances where they have asked for it, but they should not be denying it based on that because multiple filings are allowed. There are some lawsuits being filed, even with reference to collusion, actually, because last year the collusion attestation was not in the registration requirement. And so people, USCIS going after companies who colluded for last year's cases, they will have, USCIS is going to have some lawsuits that they'll have to answer to. So they can't just do whatever they feel like. They have to follow the laws. And so at the time of stamping, they should not be asking you about multiple filings. You can just tell them the law. Send them a copy of the law that it is allowed, and here's a copy of the law.
Okay. Shanti, it's already 1 o'clock. Do you have time to go through a few more questions, or do you want to take them offline?
Sure, we can. I see quite a few, but we can go through a few more.
Okay, all right. Let's scroll them through. Do I have any chance of my visa getting revoked in future after the approval of H1, one company with multiple registrations?
What does this person mean by one company with multiple
that was under brackets. Approval of H1
with multiple future after the approval of H1 with multiple. So if it's collusion, then you will have a problem at some point or the other. My suggestion is not to file. Again, it's up to you what your risk tolerance is. If you are a beneficiary who has done multiple registrations through different companies, then it's completely okay to file. You should go ahead and file your H1.
Okay. If I enroll in day 1 CPT and my lottery is selected in second lottery, can I still file petition if my previous employer gives me an offer letter? What must be the start date? Will I be COS or counselor process?
That depends on what the whether you're consular processing or CS, it depends on how you file, how your employer files the petition. If they file it as change of status, you'll be change of status. If you file it as consular processing, that's what it'll be. Day one CPT is fine if your college allows it. They are not denying cases because of day one CPT. They are sending RFEs in some instances to show why day one CPT, whether the university allows day one CPT, why college needs day one CPT, but most of those RFEs are getting approved.
Okay. Do we need original written offer letter to file H1, or oral offer letter is also fine?
We don't even need an offer letter to file a H1, so it's not like a compulsory document. So even if you don't have an offer letter, you can file the H1 because the filing of the H1 petition itself shows that the employer has a job for you.
Okay. Currently, I'm working with an employer with H-1B is filed. While my petition is pending, for some reason, my current project ended. I found a new job with the same employer. Can I change the LCA and send to USCIS?
So it depends on what is your status presently. If you still have an I-94 that's valid, and if you're still on the payroll of that employer, then you can go ahead and file a second petition. If your payroll with that employer has ended and you're filing based on another pending petition, then it's possible that before they approve the second petition, they might wait for the first petition to get approved. They want to make sure that the first petition is approvable before they approve the second petition. It's called a bridging petition.
Okay. I have registered from 3 different companies and got picked from one. What if I don't have an official offer letter from the other 2 and they refuse to share one? Do we need the offer letters from them?
Again, I think same thing. You don't have to worry about offer letters. We answered this question, so let's go to the next question.
I guess that's the last one. If I filed from 5 companies and got picked from 3 companies, and if I choose one company to process my H-1B application, the company which I am applying through doesn't have collusion with the other 4 companies, but if other 4 companies might have collusion, what would USCIS do in this scenario?
So they're only looking at the company that has collusion. So if you file with the company that doesn't have any collusion, there's no issue. You can go ahead and file your H1.
Right. On that note, we conclude today's session.